Hello, everybody. Today is what we're talking about. 3 arguments an attorney cannot make during closing arguments. See that? 3 arguments an attorney cannot make during closing arguments. That's what we're talking about today. So now, here's what we're going to do. We're going to hang out for just a few moments because today's topic is on Facebook Live and also YouTube replay. 3 arguments an attorney cannot make on closing arguments. Hey everybody, nice to see you. So, as you notice, my fancy 3D graphics. Okay, here you go. There's nobody else who uses it. Actually, there may be 1 or 2 people, but nobody who uses it like I do. So here we are with 3 arguments an attorney cannot make on closing arguments. And by the way, if you're joining me for the very first time, or if you're a repeat viewer, what I encourage you to do is say hi in the comments. Let me know that you're here, and if you have questions, and what I encourage you to do is ask them, because I'll be happy to answer them as soon as I'm done chatting with you and letting you know exactly what it is that we're talking about today. So today we are talking about 3 arguments an attorney cannot make during closing arguments. All right? So that's exactly what we're talking about. Leave a comment. Let me know you're here so we can go ahead and get started. 3 arguments an attorney cannot make on closing arguments. That's what we're talking about today. Hi everybody, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So, what are we talking about today? Well, you know what the topic is, right? 3 arguments that an attorney cannot make during closing arguments. All right, so here's the scenario. Let's say this is a medical malpractice case, right? You brought a lawsuit against your doctor claiming that he violated the basic standards of medical care. You claim that he was careless and that his carelessness was a cause of your injuries. And now you have a medical expert. You have multiple medical experts who confirm that, number 1, there was wrongdoing. Number 2, the wrongdoing was a cause of your injury. And number 3, that your injuries are significant and permanent. So now that allows you to go forward. Well, guess what? The doctor turns around and says, hey, wait a second, why are you suing me? I did nothing wrong. I don't understand. There's no point of you suing me because I did nothing wrong. So, what happens next? The doctor says, I didn't do anything wrong. Don't sue me. Well, it's too late for that. So now what happens after that? Instead, he turns around and says, hey, I did nothing wrong. And even if I did, nothing I did caused or contributed to your injuries. That's number 2. That's his second defense. Hey, Kevin, nice to see you. Nice to see you. Thanks for joining me. Okay, so today we're talking about 3 arguments that an attorney cannot make on closing arguments, during closing remarks. 3 arguments, that's what we're talking about today. So the doctor's second defense is, hey, even if I did something wrong, I didn't cause or contribute to your injuries, right? And then he turns around and says, listen, if I did something wrong, and maybe I did or didn't cause your injuries, guess what, Mr. Patient? So did you. You caused and contributed to your own injuries. That's another defense that let me try that again. That's another defense that the doctor will commonly use. So then, number 4, and this one hurts. He turns around and says, you know what? Even if I did something wrong and I may have caused you harm, guess what? The injuries that you claim you suffered because of my carelessness, they're not really as bad as you claim them to be. That's the 4th common defense that we see over and over again in these types of cases, right? Scott, nice to see you. Thanks for leaving a comment. If you have questions, as always, leave comments here, and I'll try and get to them as soon as I'm done chatting about the topic today. So 3 arguments an attorney cannot make on closing arguments. So nice to see you guys. Thanks for joining in. So this is what happens now that you brought a lawsuit. The doctor turns around and says, hey, I did nothing wrong, and now you have to go forward with the litigation. So that's exactly what happens. Your litigation goes for at least 2 to 3 years here in New York. That's how long it will take. And now, it's a hard-fought, contested case. You say it's day, the defense says it's night. You say it's 2 o'clock, they say it's 10 o'clock. Whatever it is that you're arguing, they say no, just the opposite. So it's very frustrating for you as an injured victim, as an injured patient who's trying to get compensation, trying to get money as a form of compensation for all the harms and losses and injuries that you suffered. And guess what? The doctor has none of it. He wants none of it. And guess what? He's not paying you a dime voluntarily, which means you have to go to trial. That means that you have to get a jury of 6 people in the community. Here in New York, we have 6 jurors who decide whether or not you are more likely right than wrong. So 6 people of the community have to decide whether or not the doctor was careless based upon the proof and the testimony that you are putting on a trial. Then they have to decide whether that carelessness, whether, assuming the doctor was careless, they have to also decide whether his carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause, because there could be multiple causes. So then, assuming that they find, yes, that his carelessness was a cause of your injury, now they will get to determine how much money you are to receive for the different types of damages and injuries that you suffered. So now, here's a very interesting point. So you go ahead and put on all of this testimony. You put on all of this evidence, right? And then, after the defense has done the same thing, the defense puts on all of their testimony. They put on all of their evidence. You know what happens next? Well, now you've reached the end of the trial. There's no more testimony or evidence to put on. And I'm just going to hang out 1 second. Give me 1 second right here, because I'm going to get my... There we go. All right. Perfect. All right. So what happens next? What happens next is that now we are going to get to closing arguments. And closing arguments is an opportunity for each attorney to show the evidence in the case, to show what conclusions they want the jury to reach. It's a time for an attorney to use passion. It's a time for an attorney to use logic, to use reasoning, to show the jury that you are entitled to verdict in your favor. That's the opportunity for the jury to put all the pieces of the puzzle together, to now show the jury, listen, based upon all the evidence and all the testimony here, the only conclusion you can reach is for a verdict in my client's favor. So now, this is very interesting. Today's topic, you know, is 3 arguments an attorney cannot make on closing remarks. So closing remarks are designed to get these jurors to understand what the testimony was and to lead them to the conclusions that you are entitled to a verdict in your favor. So let me give you 3 examples. 3. 1, 2, 3, count them. 3 examples of things attorneys cannot say in order to try and influence the jury to get a verdict in your favor. The very first one, the most basic, is the attorney says to the jury, ladies and gentlemen, I believe in this case that my client is entitled to a verdict, and I believe that this witness is a liar. You want to know why? It's because the attorney's opinions and beliefs are meaningless. They carry no weight with the jury. And, well, at least they're not supposed to. An attorney is not supposed to interject himself as an opinionated person as to where the jury should be, as to what they should do, as to what actions they should take. So if I were to go ahead in front of the jury and say, ladies and gentlemen, hey, I believe that this doctor is lying. I believe that my client is entitled to a verdict in our favor. It doesn't matter what I believe. It only matters what the jury believes, what testimony they believe, what witnesses they believe, because credibility is everything in a case like this. So if an attorney were to argue that his own personal beliefs should sway the jury, that's argument number one. That should never, ever take place. And the defense attorney would be totally within his right to go ahead, jump up out of the seat, and yell out, objection, judge, that's an improper argument. And you know what? The defense attorney would be absolutely correct, because an attorney should never be interjecting himself as to his own personal beliefs. It's okay to make an argument saying that a doctor is being less than truthful or is lying, based upon the evidence, based upon the testimony. That's fine. But for me to go ahead and say, hey, I personally believe that the following things took place, and I believe that the facts are as follows. No. I wasn't there. I didn't witness these things. I didn't overhear these things. I am not the one that the jury is supposed to be deciding this case upon. The jury is supposed to decide based upon the evidence and the testimony. And the judge even tells the jury that the attorney's arguments are not evidence. So that's argument number one that an attorney should never be making. So let's talk about, here we go, my fancy 3D ticker tape. Let's talk about the second of 3 arguments an attorney should never be making during closing remarks or closing arguments. The second one is to argue that the doctor whom you have sued is very wealthy. Ladies and gentlemen of the jury, I want you to know that Dr. Jones is very, very wealthy. And no matter what verdict you give my client or how much money you give her, it's not going to affect Dr. Jones financially at all. How do you like that argument? Now, that's a very interesting argument. It's a very compelling argument for me to try and make. Guess what? That will probably result in an immediate appeal and a reversal. And now we'll have to try the case all over again. Why? Because again, the jury is not supposed to evaluate the case based upon the doctor's ability to pay or not pay. That's not the issue that they're supposed to decide. Instead, the jury is going to decide, first, whether or not the doctor violated the basic standards of medical care, whether he was careless. That's really question number one. It's yes or no. If the answer is no, case is over, and my injured victim, my injured client goes home without a dime. If the answer is yes, the second question the jury has to answer is, was the doctor's carelessness, his violation from the standard of care, was that a cause of your injury? That's known as causation. If the answer is no, case is over. We go home without a dime. If the answer, however, is yes, now guess what? Now the jury has to decide how much money you are to receive for the different types of damages, such as the pain and the suffering you endured from the time of the incident up until the time today, up until the time of trial, and from the time of trial into the foreseeable future for the remainder of your life. So there are many elements of damages that are possible, but to argue that because the doctor is financially well off, because he's very wealthy, that to argue now that the jury should give you a large verdict in your favor, should give you a lot of money because the doctor can afford to pay for it, it's not going to make a dent in his finances? No, no, no. That's argument number two that you can never, ever make. Doing that will generate an immediate objection. The judge is going to sustain the objection, which tells me I cannot make that argument. And if the defense, if the doctor loses the case, guess what? I'm screwed because now, on appeal, that case is going to get reversed. Now we're going to have to try the case all over again with an admonishment to me, hey, Oginski, you cannot use that argument during closing arguments. So now you know 2 of 3 arguments an attorney cannot make during closing arguments in a medical malpractice trial here in New York. So now, what's argument number 3? I'm going to get to that in just a second. All right. Well, thanks for sticking around. We've talked about number 1 argument that you cannot make is that I cannot insert myself and say, I believe that my client is entitled because, or I believe the facts are as follows. No, no, no. That's argument number 1 that you cannot make. Argument number 2, hey, the doctor's financially well off. Any verdict you give, any money you give my client is not going to make a financial impact on this doctor at all. Okay, that's argument number 2. That's a no-no. So, here we go. The third argument in today's video that an attorney cannot make during closing arguments is, get ready for this, get ready, the financial status of the injured patient. So let's say, for example, that my client, the injured patient, is very poor. She has no money to her name. If I were to argue, ladies and gentlemen, if you don't give my client a whole bunch of money, a lot of money for her injuries, she's going to be homeless and destitute in the next month. You got to do something. You got to give her a lot of money, a boatload of money. Could you imagine that type of argument? Now, some people may say, hey, that's true. And you know what? That may in fact be true. She may not have any money at all. She may have no ability to pay for her medical expenses. She may have no ability to support her family. But the point is, I cannot use that argument to the jury to try and get them, to try and persuade them to give us a verdict in our favor. And let me tell you why. Because her financial status has nothing to do with, number 1, whether the doctor that she sued was careless. That, her financial status has nothing to do with, number 2, whether the doctor's carelessness was a cause of her injury. Very, very important. So that type of argument is done to try and sway the jury, to let them know, hey, there's a financial discrepancy here between the doctor and the injured patient. And hey, you should be helping out the injured patient. Why? Because she's financially destitute. She's really, really poor, and now needs your help, ladies and gentlemen of the jury, in order to go ahead and move on with her life. No, no, no. That's argument number 3 an attorney can never make during closing arguments in a medical malpractice trial here in the state of New York. So why do I share this quick information with you? I share it with you just to give you a sense of what goes on in these types of medical malpractice trials. Because so many people are familiar with what goes on TV. Hey, Stephen, nice to see you. Aside from the arguments, what about making factual statements that were not presented or entered into evidence during trial? Excellent point. So Steve's an attorney in New Jersey, and he raises a very interesting point. If I go ahead and try and have the jury reach a decision or a conclusion based upon evidence that was not presented at the time of trial, I clearly am going to run the risk of getting my case appealed and overturned. So even if we do win the trial, there's a very good likelihood that on appeal, the judges who review the transcript of what occurred during the course of trial, the defense is going to argue, hey, this verdict is not based upon the evidence that was presented. And if the judges at the appellate court concur and they realize, yes, that's true, Oginski made these arguments about evidence that was never presented at trial, guess what? Now their verdict is no longer based upon the evidence that was introduced at trial. And as a result of that, the case is going to get thrown out or overturned, and now we have to try the case all over again with a new jury, and we start from scratch again. So that was a great point, Steve. I appreciate you bringing that up, because that's also something that an attorney cannot use during closing arguments. So now, not only do we have today 3 arguments that an attorney cannot make during closing remarks, but now you've learned a 4th one, because Steve, my good friend from New Jersey, an attorney, was so kind enough to point out that if an attorney starts talking about information that was never presented at trial, it's not considered evidence that the jury will be allowed to consider in their deliberations. So I hope you found this information helpful. I hope you found it interesting. I hope you found it entertaining and I said educational, didn't I? Well, I hope you found it entertaining and, importantly, eye-opening. And the bottom line is, if you have questions about your matter that happened here in New York and you have not yet started a lawsuit because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at, follow the bouncing finger, right? Not the ball, the bouncing finger. Ready? 516-487-8207, or by email at Gerry, here we go, over here, at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I want to thank everybody for watching, and if you're watching this on Facebook, make sure you share it with your friends. And if you're watching this on the YouTube replay, make sure to share and like it as well. I'm Gerry Oginski. Have a great day, everybody. Bye-bye.